getting a divorce is a complicated and often confusing process. In this video, we'll review the steps of getting a divorce in Oklahoma based on incompatibility. These steps are explained here from the view of the petitioner or the person who filed the case. This is a follow-up to our previous video, Steps of Getting a Divorce, Part 1. Here, we'll continue to show you the process of getting a divorce after the initial filing stage and through to the final order. This video is intended as general legal information about divorce in Oklahoma. This is not legal advice. If you are feeling unsafe or experiencing domestic violence, please visit the websites in the description or call the numbers below for emergency resources. After you file the proper paperwork with the court and serve the respondent with those papers, there are many steps you'll need to take before the case ends with a final order. Once the respondent has been served, they have 20 days to file an answer to the petition. The answer is where the respondent can say what they want to happen in the case. If they do not file an answer, they are in default, and you can continue with the divorce without their input. To learn more about default, please watch our Court Basics video on default judgment. Discovery is the information gathering phase of a case. During discovery, you and the respondent will exchange information and documents about assets, debts, income, and other related topics. This ensures both sides have all the information they need to make decisions about the divorce. After you filed the petition and served the respondent, you must wait at least 10 days before you can request the final order. The waiting period is 90 days if you have minor children from your marriage. There are certain circumstances where the judge may allow you to skip this waiting period. Most of the time, if you have minor children from your marriage, both you and the respondent must attend a 4-hour parenting class. This class focuses on how divorce can affect your children and covers other topics like family violence and substance abuse. Some counties allow you to attend this class online, but others require you to attend in person. Check with the court clerk for any local requirements and the cost of the class. Some counties might require that you attend some additional meetings and conferences. Those may include the following. In a temporary order hearing, the judge will issue temporary orders. A temporary order covers most of the issues in a divorce, including decisions about property, child support, child custody, and sometimes more. This order will be in effect until the judge signs another order that replaces it. In mediation, you and the respondent try to reach an agreement on disputed issues with the help of a neutral facilitator. In a pre-trial conference, deadlines for discovery, motions, and other procedural steps are set and tracked. Future hearings are also scheduled. This is where the roadmap to finish the case is created. If you can't reach an agreement after these steps, the case goes to trial. During trial, you'll go to court, where both sides will have a chance to present their arguments and evidence to the judge. The judge will make the final decision if there is no agreement. If you don't need to go to trial, you still need to go to court for a hearing to get the final order, also known as the Decree of Dissolution of Marriage. Once all issues are resolved, the judge signs the final order, which finalizes the divorce and outlines the terms you agreed on or that were decided by the court. After receiving the final order, please remember to file it with the court clerk. When you file the final order with the court clerk, it will make it easier to enforce it in the future, if problems arise later on. Make sure the court clerk provides you with certified copies, because you might need them to complete some tasks. You might also need to do other things after the divorce, like changing your last name on government documents, retitling divided property, providing notice to your children's schools, and sending a copy of the final order to your spouse. Remember, divorce can be complicated. There are a lot of steps in most divorces, and every case takes a different path. If you need a lawyer or want to learn more, here are some resources that can help. This was brought to you in part by the Oklahoma Access to Justice Foundation and Legal Aid Services of Oklahoma. Thanks for watching.